Thanks for coming, everybody. So here's a little roadmap. First, we'll talk about how I got involved in this work, which started, of course, right here. And then I'll just give some current examples of some cases I'm working on. And then we'll talk about the history of trans exclusions, and then get into the legal causes of action. So when I was a student here, I graduated in 2005. And this was the student health plan. It had an exclusion for services and supplies that are related to sex change surgery or the reversal of a sex change. So for my, I did a winter writing project in my 3L year researching all the different ways I could sue Harvard over this exclusion. So if they're going to be teaching people how to be lawyers, they should probably not have discriminatory policies. And so I was ultimately, through a lot of advocacy and filing charges of discrimination with the Massachusetts Commission Against Discrimination and the Cambridge Human Rights Commission, able to get those exclusions removed. And, but yet still, I'm 14 years later still working on these issues in a variety of contexts. So I want to tell you about some of those. So this is Nancy Menusan, and she was denied coverage for augmentation mammoplasty, breast augmentation, under her employer-based health plan that is administered by Aetna. And so all of this is a medical necessity denial. There's two main types of cases I'm going to be talking about. This is under the medical necessity bucket, where there's no exclusion across the board for trans-related health care, but they're saying that this particular procedure is not medically necessary. So all of the insurance companies have these clinical policies where they list criteria for when they cover gender reassignment surgery. And it will say, to have bottom surgery, for example, you have to have 2 letters from mental health providers, you have to be age 18, you have to have been on hormones for a year unless it's contraindicated for some reason, you have to have capacity to provide informed consent, and live full-time for a year. Those are the types of things that they want to see, which are loosely based on the World Professional Association for Transgender Health, or WPATH's standards of care, but oftentimes the insurance companies make up their own things. Like some of them have just outdated things saying like you have to be on testosterone before having top surgery if you're a transgender man or a non-binary person trying to get top surgery, and that's not required under any standards of care. So Aetna specifically says they have this laundry list of things, including breast enlargement procedures that are considered to be cosmetic, and the other things are facial gender reassignment surgeries and voice surgeries that they categorically say are cosmetic. So Nancy was not given an opportunity to demonstrate medical necessity. The plan says medically necessary surgeries will be covered. Her surgery, according to her providers and medical literature and standards of care, is medically necessary, but because of Aetna's categorical exclusion, she was denied care. So we are working with her and another client to challenge this, and this would apply to every single plan administered by Aetna across the country. And just for your information, on the web, on transcendlegal.org, you can find the medical policies for 126 different insurance companies and different policies. So when someone's trying to figure out, does my plan cover surgery, this is a key document that they need to find, because it will tell you right off the bat if you're going to be automatically denied for something. But another kind of case involves, like I mentioned, blanket exclusion. So does anybody recognize the guy in the middle? Yeah. So if you saw the episode, you may recall that he had to have a fundraiser to pay for his top surgery, but they didn't explain why. And the fact is, he's an employee at the university system. He's at the University of Georgia, which is part of the university system of Georgia, and they have one employee health plan for all of the universities. And there's an exclusion in there for sex change surgery and sex change drugs. That's the actual language that they use, even though that's not what's used in the medical literature. So we wrote to them, and they did not want to voluntarily remove the exclusion. So we sued them in the Middle District of Georgia, and we had oral arguments in February on the motion to dismiss. And we're hopeful that it will be resolved outside of court, not just so that it's resolved quickly and Skylar can move on in life. But, 14 years ago, Harvard removed this exclusion, but actually the University of Georgia's student health plan does not have an exclusion, but these staff plans still maintain their exclusions in a lot of cases. Another case I'm working on is Anna Lang. She's a sheriff's deputy in a small town called Warner Robins, which is just south of Macon in Georgia. And I was connected to Anna because she came up to New York City to have a consultation for genital reassignment surgery. And she had previously called her insurance company, and she had the surgeon call before she came all the way up to New York to have her consultation, and she was told it would be covered. But when her surgeon actually submitted pre-authorization, it came back as denied due to a blanket exclusion, which again is a sex change surgery exclusion. And the reason why it's the same as in Skylar's plan is because both of those plans are administered by Anthem Blue Cross and Blue Shield, which is a third-party administrator for what's called a self-funded plan. So these two plans are, a self-funded plan is where an employer has a pool of money that they use to pay out the claims. They hire an insurance company like Aetna or like Aetna or Cigna or Anthem to decide which claims to pay and which not, but Anthem is not the one that's on the hook for paying out the money of the claims. But nonetheless, Anthem has a template plan that they give to employers, which still has this exclusion, even though Anthem's own employee health plan doesn't have an exclusion, and the plans that Anthem sells on the marketplace as part of Obamacare don't have the exclusion. So I'm a little unclear about why, if they are not the ones who are paying the claims, why they care one way or the other if this exclusion is in there. But they've been fighting it and seem to want to maintain it. So we wrote to Houston County, this little county, and they ignored us. So I said to him, the county attorney, we haven't heard back from you, so we're going to show up at your Board of Commissioners meeting and ask to, we're going to testify in the public comment period. So we did that, and they announced at that meeting that they weren't going to remove the exclusion for this year. So we have drafted a charge of discrimination with the Equal Employment Opportunity Commission, and we'll be filing that imminently against both Anthem and Houston County. And another case I'm working on, I'm also the interim senior staff attorney at the Transgender Legal Defense and Education Fund. And so this is a TILDEF case along with Lambda Legal. And this involves the North Carolina State Employee Health Plan. And I was first contacted by somebody, a state employee, back in 2016 when she couldn't get coverage for her 18-year-old son. And so I organized some testimony at the Board of Trustees meeting for the health plan, and it turned out they were already looking into this because of the regulations that were going to go into effect under Obamacare, the Affordable Care Act, Section 1557, the non-discrimination provisions of the Affordable Care Act. So they actually removed the exclusion for the 2017 plan year, and people like Sam there in the middle, just because of insurance bureaucracy, he got his pre-authorization, but his surgery wasn't scheduled until March of 2018. And then the treasurer is an elected position, and it switched over from a Democrat to Republican, and they elected not to continue coverage in 2018. So he had to suddenly figure out how to pay out of pocket for his surgery. And this is Mike Bunting and Shelley Bunting and their son, who's not named in the suit because he's 13. He'd actually had a puberty delaying implant placed in 2017. This is a very expensive treatment for whatever reason. It's like $10,000 to get the implant. And it only lasts for about 18 months. It can last longer, but that's when they like to take it out. So it's due to be replaced now, and now there's an exclusion in the plan. And they actually purchased a plan on the marketplace. This is Blue Cross Blue Shield of North Carolina. that's administering this self-funded plan, and they purchase a Blue Cross Blue Shield of North Carolina plan on the marketplace that doesn't exclude it. So, but this is what the treasurer had to say. What happened to the clicker? I don't know. The legal and medical uncertainty of this elective, non-emergency procedure has never been greater. Until the court system, a legislative body, or voters tell us that we have to, when to, and how to spend taxpayer money on sex change operations, I will not make a decision that has the potential just to discriminate against those who desire other currently uncovered elective, non-emergency procedures. And so what he's talking about there is anytime there's a news article about trans healthcare coverage, somebody's always invariably commenting, well, what about my physical therapy, and what about this, and what about that, and of course, what about my breast augmentation, what about my facelift, you want all these cosmetic procedures, why can't I get mine? So, but yet, the North Carolina State Health Plan had covered this care as medically necessary in 2017 and didn't have a problem with it. So, this is clearly politically motivated, but what he's saying there is certainly what people think about this healthcare. People who don't know anything about trans healthcare tend to think it's elective and cosmetic and not as important as other healthcare. So, and of course, judges come into it with that mindset too. So, there's a general perception that this is adding a benefit, that this is something extra that trans people want. It's like an optional thing, and like maybe if we're some private company with really good benefits, we're trying to be like Google or something like that, then maybe we could add it on. But in terms of like taxpayer money, we're not going to have taxpayer money going to sex changes. So it's important to understand that this is not adding a benefit. It's removing an exclusion. So we have to understand where this exclusion came from. It's not about my clicker. So when was the first trans surgery in the US? It's okay, you can guess. Yeah? Oh, wow, okay. Yeah? Uh-huh. Oh, wow. This is Alan Hart, and he was actually a medical doctor. He graduated from medical school. So in medical school, he learned about inversion, which was what they were calling sort of lumping together homosexuality and trans status. And he went to a psychologist, doctor, can you help me? And they decided that he would transition. And then he got a hysterectomy in 1917 by actually the same person. He's a PhD MD. So this is the first documented case, at least one of the first that we know of, because the surgeon wrote it up in a medical journal, and you can actually go onto Google Books and read it and read all about the history of Dr. Hart. And what he did was, he became a practicing doctor. He got his documents legally changed. He got his name changed. He married a woman, and he did have a successful medical career, but he kept getting kind of run out of town anytime that his history came up, and then he started getting ostracized and had to keep moving. And he became an author as well, and he wrote some fiction. I started reading one of his books called The Undaunted, and it kind of is semi-autobiographical about, the problems that he had with discrimination. So, but in that article, Dr. Gilbert, he said, let him who finds in himself a tendency to criticize offer some constructive method of dealing with the problem on hand. He will not want for difficulties. The patient and I have done our best with it. And yet, 100 years later, trans guys are still fighting to get hysterectomies covered under insurance. And of course, 1917 is, we're talking about here in the US, but globally, trans surgeries have been going on for thousands of years. The Hijra in India, Aboriginal people in Australia, in biblical times, eunuchs. There's been a long history of religiously sanctioned genital surgeries, which, obviously were being taken advantage of by people who needed them to address their gender dysphoria. And the first modern genital reassignment surgery was in Germany. She had an orchiectomy in 1922, and then in the early 30s, she did have vaginoplasty. And she was the same. Then, if you saw the Danish Girl, which is based on the life of Lily Elbe, she was another early person who had gender reassignment surgery in Germany. Does anyone know what this is? What? Yes. Not quite. Yes. So Nazi book burning, and a huge part of what they were burning was this library, the Institute for Sexual Research. And if you go to the plaza now, there's this installation called Library, and it's just empty bookshelves. And so Magnus Hirschfeld created this institute, and he traveled around the world. This was not just his own research, but he did travel around the world and gathered books about sexuality from all over the world. And he was one of the first people. His motto was justice through science, and he was trying to get rid of paragraph 175, which criminalized sodomy. And he also made a distinction between gay and trans people, and he coined the word transvestite, which meant more transgender. And at his institute, he did have trans people on staff who worked as maids, because of the employment discrimination we face today was existent then too. The first surgeries were performed in conjunction with the institute, and he would help people who were being arrested by the police for cross-dressing, giving them doctor's letters so that they wouldn't get in trouble. And then, so I mention this because, because we tend to think of trans surgeries as being new. Well, the fact is they were being done. As soon as the technology basically came about to have this kind of surgery, trans people were using it, and then it was deliberately attacked and destroyed because of anti-trans and anti-gay sentiments. The first phalloplasty was had by Michael Dillon in 1946 to 1949. He actually had 13 different surgeries during that time. And he later he's the one there in the middle, he became the first Westerner to become an ordained Tibetan monk. So again, that's much earlier than most people realize these surgeries were happening. The hormones were isolated in the early 30s, and then very quickly we became able to synthesize them. And then as soon as that happened, trans people were starting to use them. Does anyone know who that is? Christine Jorgensen. She went to Denmark in 1952, and she came back and she had genital reassignment surgery, and she was a sensation throughout the country. And this was the first time that many trans people realized that they weren't alone. And they started connecting and writing to each other. And a big way in which they were connected was through Harry Benjamin, who was an endocrinologist who was the first doctor to really, in the US, to really advocate for hormones and surgery as the appropriate treatment for gender dysphoria, as opposed to just telling people you're delusional and you need to get a psychological cure to stop thinking this way. And he directly was involved with referring a lot of patients to the Johns Hopkins Gender Identity Clinic, which started in 1966, but it was later shut down in 1979 through the work of Paul McHugh, who is Catholic and didn't approve of it for religious reasons, and another person, Dr. Meyer, and they did some studies trying to show that the surgery wasn't effective. They were kind of flawed studies, but they used them to shut down the clinic. And there were about 15 or 20 clinics throughout the US. And then once it got shut down, it really, it was taken out of the academic context. So then it got put into the hands of just a handful of providers, and it was hard to access surgeries. Janice Raymond, she wrote The Transsexual Empire, and she was instrumental in getting Medicare, which is for people, retirees and people on disability, to have an exclusion, in so that so taxpayer money wasn't going to gender reassignment surgeries. And it wasn't until 2014 that national coverage determination was found to be not based on medical evidence anymore. Even if if it was at the time, that's debatable, but it certainly wasn't in 2014. So then, what about in the private, getting actual insurance coverage for it? Well, there was a case in 1979 in New York where Aetna tried to deny coverage under the cosmetic exclusion. And the court said, while many seem appalled at such surgery, it nevertheless has been demonstrated proven benefits for its recipients, although psychological in nature. And so at that point, the insurance companies kind of realized, well, if we can't exclude the surgery under the cosmetic exclusion, we better put in explicit exclusions. And I think this is part of the origin of these explicit exclusions, because the same thing was happening in the Medicaid context in the late 70s in California. People were winning cases where the courts were like, there is no way that turning a penis into a vagina is cosmetic, so it has to be covered. But we're left then with this legacy of explicit exclusions, and that creates this cycle of problems. So if you don't have insurance coverage, you're not going to have providers who are covering it because they're not getting paid for it. So it's only a handful of people who can afford to pay out of pocket who can access care. And there were just literally a handful of surgeons in the US who could do these surgeries. And then, so there's a lack of access to treatment, and then there's no studies showing the effectiveness because of the small numbers of people who are having the surgery, and also because it's not being done in an academic context where there's research. And because it's also not being done in research teaching hospitals, people are not being taught how to do this. And then there's just this general lack of respect for trans healthcare. It's not taught in medical school. Then trans people can't even access basic primary care, not even necessarily trans-related healthcare, but trans people avoid going to the doctor because people aren't qualified to deal with that. So, so I choose to focus on getting the coverage as my entry point into breaking this cycle of exclusion, and that's exactly what's happening. There's been an exponential increase in the number of universities that are reopening their gender clinics, and there's now fellowship programs like at Mount Sinai to train surgeons. So we are seeing access increasing once again. A very helpful thing was the passage of Section 1557, as I mentioned, the non-discrimination provision of the Affordable Care Act in 2010. If you happen to remember, there was the Obamacare kid whose mother had died and was very instrumental in campaigning for Obamacare. Turns out she's a trans woman. And so I think that's very fitting, because under the Obama administration, they passed regulations under Section 1557 to explicitly say, number one, that trans people had to be housed according to gender identity in sex-specific facilities like drug treatment facilities and hospital rooms, that you couldn't deny care based on gender. So if a trans guy needs a gynecological exam and he's listed as male on his insurance, you can't deny it just because of that, although that had been happening in the past. And it also said that you could not have explicit trans exclusions like those sex change exclusions, and it also said you could not have discriminatory denials like that breast augmentation. So even if you didn't have the exclusion, if your denial was based solely on the diagnosis of gender dysphoria, that was also banned. However, the regulations were scheduled to go into effect on January 1st, 2017, and some Catholic healthcare providers, along with a bunch of states like Texas, sued, and they sued in the Northern District of Texas with the judge who likes to issue nationwide injunctions. So he did, in fact, they also were complaining about the abortion, any kind of abortion regulations. So a nationwide injunction was issued, and the Office of Civil Rights of the Health and Human Services Department was no longer able to enforce this regulation. They had been enforcing it. There were, on the website, there were various enforcement actions that had been undertaken. They, for example, went after a mammogram screening program that was not allowing trans women to participate. They went after a hospital in Brooklyn that was misgendering patients and treating them poorly. And then once the Trump administration came into office, they took all that down from the website, and they are no longer enforcing the regulations, and of course they're no longer defending the regulations. And they've been saying now for years that they're going to issue new regulations, and it's like any day now, and we don't know when these regulations are going to come out. What are they going to have in them? Are they going to have like religious-based exclusions? What exemptions? But they're definitely trying to roll back these trans protections. But nevertheless, Section 1557 is a statute. It's still in the books, and you can bring a private cause of action to enforce the statute as well as the regulations. So people are doing that. So there's a case, Prescott v. Rady Children's Hospital. Sad story. Rady holds itself out as being trans-friendly. So the mom sent her son there when he was feeling suicidal, but they consistently misgendered him, and he ultimately committed suicide once he got out. And so the case is moving forward. That I didn't explain that Section 1557 prohibits sex discrimination, disability discrimination, age discrimination, race discrimination in health programs or activities that receive federal funding. So that applies to most healthcare providers if they receive Medicaid, Medicare money. So sex has been interpreted to protect trans people, to prohibit discrimination on the basis of gender identity. So these are some of the legal protections that we use to challenge exclusions and denials of trans-related health care. So Title VII prohibits sex discrimination in employment. The Americans with Disabilities Act prohibits disability discrimination in employment and public accommodations. Title IX prohibits sex discrimination in education. That includes employees of educational institutions. So we brought Title IX claims in Schuyler's case. And Section 5057 only applies to healthcare entities, so it doesn't apply to most employers unless the employer itself is a healthcare entity like a hospital. If you're a federal contractor, the Office of Federal Contractor Compliance Programs enforces specific regulations that prohibit gender identity discrimination in employment, including they have specific regulations about having trans exclusions in healthcare plans. And if it's an insurance plan, state insurance law and bulletins apply. Those don't apply to a self-funded plan, the kind that I was talking about earlier, because those are not considered to be insurance. The federal law called ERISA, the Employee Retirement Income Security Act, allows employers to have the same plan across all 50 states, and it says that state non-discrimination laws and state insurance laws don't apply. So if it's a public plan, state non-discrimination laws, and because ERISA doesn't apply to public employers, and the Constitution would apply. So we brought equal protection claims in Schuyler's case. So the Americans with Disabilities Act prohibits, so it defines, prohibits disability discrimination, defining a disability as a physical or mental impairment that substantially limits one or more major life activities of an individual. And there were some amendments in 2008 that clarified that this also means affecting a major bodily system, such as the endocrine system or reproductive system or neurological systems. So I'm curious what your initial gut reaction is to using disability law to protect trans people. Or if you don't want to say, you can say, I've heard people say this. What, yeah?
I've heard that it has proved to be an effective weapon in some litigation, but that it is controversial because of the connotation of identifying a personal identity issue as a disability.
Mm-hmm.
I've heard similar things, and then also I think in debates then it comes back to So there's like, yeah, just like going back and forth.
Yeah, and I will also mention, currently gender dysphoria is in the Diagnostic and Statistical Manual put out by the American Psychiatric Association, and it was changed from gender identity disorders in 2013. They changed it to gender dysphoria, and people talk about how homosexuality used to be in the DSM and it was taken out in the 70s, and like, don't we want that for trans people? Well, separately, the International Classification of Diseases, which is put out by the World Health Organization, the ICD 11, the next edition, has moved, they've called it gender incongruence, a new term. Well, actually, it's kind of an old term, but and they've moved it from a mental health diagnosis to a physical categorization. So, however, the United States just adopted the ICD-10 like 20-some years after it was put out by WHO. So it's going to be another 20, 25 years before we get to that point in the US. So in the meantime, in order to get insurance coverage for trans-related healthcare, you do need a diagnosis. And sometimes for hormones, people use endocrine disorder not otherwise specified, but otherwise the codes don't necessarily really fit. Like there's codes for like large breasts on men and stuff like that, but to be precise and it's gender dysphoria is the diagnosis that you need to use. So yeah, ableism, like trans people reacting specifically to having a mental health diagnosis, like that's even extra worse than just having a diagnosis in a lot of people's minds. And not just, this is out there in general. So there's actually an exclusion in the ADA for transsexualism and gender identity disorders not resulting from physical impairments. This is the result of Jesse Helms, and they just kind of pulled a page out of the DSM and includes other things. It includes alcoholism, it includes homosexuality, which, and so these kind of things that they were placing moral judgments on that they didn't want people to be able to assert protections for. And the predecessor to the Americans with Disabilities Act is the Rehabilitation Act, which applied to entities that receive federal funding. So there had actually already been some cases involving the post office, for example, where trans people were protected under the Rehabilitation Act as a disability. So, so for a long time, trans people were not able to assert any protections under the ADA because of this exclusion. But then with the kind of just growing acceptance of trans people and also this change in diagnosis in the DSM-5, people started bringing cases and winning. So there's a case called Blatt versus Cabela's, which is which is an employment discrimination case, where the court said that it was protected, and moreover, if it's not, it creates constitutional problems because it would be an equal protection violation to single out trans people for exclusion from the ADA. So interestingly enough, the Department of Justice has weighed in repeatedly saying they're not going to defend the constitutionality of the exclusion, and they favor interpreting gender dysphoria as resulting from physical impairment. So that's the argument that is made, that there is a biological basis for being transgender, and so therefore it's simply not excluded by this exclusion, which is, yeah. What they probably really meant in this exclusion was intersex people. So if you did have if you had a physical difference of sex development, which most trans people don't have, then you would not be excluded. There's also a case recently in Massachusetts in the public accommodations context of prison placement. A trans woman who was in a male prison argued that it was a violation of the ADA to be in a male prison. And the thing that's really powerful about disability protections is the reasonable accommodation standard. So, obviously you know about this. If an apartment complex generally has a no pets rule, they have to make an exception and allow someone who needs a service animal. So this gets around a lot of problems around, for example, there was a case in New York called Doe v. Bell, where a trans woman who was in a foster home, a group male foster home, they weren't allowing her to wear dresses or skirts or any feminine clothing or her wig. And so she sued under the New York State human rights law, disability protections. And the court said, well, I don't really think it's disability discrimination to have the dress code, but I do think they failed to give you a reasonable accommodation. So it's fine if they generally want to have this dress code, but you needed to treat your gender dysphoria. You need to be able to dress in accordance with your gender identity, so they have to let you do it. And she was successful. So I like disability protections also because I think that this, in the context of trying to get medical treatment, like it's a disability, it's a medical issue, and these are the appropriate protections to be using. So in Title VII, back in the late 70s, early 80s, so Title VII was passed in 1964. It was kind of famously passed without, the adding sex to it was not really just debated at all, and there's not really any legislative history about it. But the court, the Seventh Circuit, this is a flight attendant who transitioned on the job, and she actually won at the district court level, and then when it went up to the Seventh Circuit, they said it's clear from the evidence that if Eastern did discriminate against Elaine, it was not because she's female, but because she's transsexual, a biological male who takes female hormones, cross-dresses, and has surgically altered parts of her body to make it appear to be female. So they're basically saying Title VII prohibits sex discrimination. It doesn't prohibit transsexual discrimination. You're transsexual, you were discriminated against because you were transsexual. Therefore, you can't use the protections under Title VII. And that's the way it was for a long time until Price Waterhouse went to the Supreme Court. So Price Waterhouse was involving a masculine woman who was denied promotions and told she needed to go to charm school, and it was all about sex stereotypes. And that was the first time the Supreme Court recognized that sex in Title VII included these gender stereotypes, and you couldn't, deny a promotion because she was too masculine. She was behaving the same way that the men were behaving. That was the culture. That was the way that they wanted everyone to behave. But just because she was a woman, she wasn't allowed to do that. So then, an enterprising transgender woman attorney in Ohio said, all right, I'll take that. And so she brought a case involving a trans woman who was going to be fired. And the Sixth Circuit recognized that the approach in those older cases had been eviscerated by Price Waterhouse. Price Waterhouse does not make Title VII protection against sex stereotyping conditional or provide any reason to exclude Title VII coverage for non-sex stereotypical behavior simply because the person is transsexual. So she was, there was two cases. I forget which one this is. I think she was a firefighter. And things like wearing makeup and nail polish, and so the approach in this case is basically like you couldn't fire a man for being feminine, therefore you can't fire a trans woman for being feminine. But the way that it's positioned, it is not really recognizing her as female, and it's kind of treating her just as a really gender non-conforming man. So that's not really going to help you down the line, for example, if there's a controversy over which bathroom she should use. Because if it's just about sex stereotypes and not about recognizing her as female, you're going to have trouble. And that's kind of exactly what happened. But, but regardless, this opened the door, and it was a novel theory, and was really helpful. So later on, you may have heard more recently about another Sixth Circuit case, EEOC versus RG&GR Harris Funeral Homes, which is up for cert at the Supreme Court. And they said gender or sex is not being treated as irrelevant to employment decisions if an employee's attempt or desire to change his or her sex leads to an adverse employment decision. In this case, the decision to not provide equal compensation under the health plan. an employer cannot discriminate on the basis of transgender status without imposing its stereotypical notions of how sexual organs and gender identity ought to align. So if you read that opinion, the Sixth Circuit is kind of pretending that they weren't doing anything different than they had done previously, but they are, because they're very clearly saying that transgender discrimination is per se discrimination, not because trans people are a separate protected class, but because it's impossible to discriminate against somebody because they're transgender and not take sex into consideration. Another approach that courts have taken is the Shore v. Billington approach. And this involved the Library of Congress. And they said the library's refusal to hire Shore after being advised that she planned to change her anatomical sex by undergoing sex reassignment surgery was literally discrimination because of sex. In this instance, Diane Shore was a terrorism expert. And of course, when you're hiring with the government, there's testing and rating, and so she was clearly the top-ranked candidate. There was no question. And so when she got the job and she informed them, she had a meeting prior to starting, said, you know what, I'm gonna start as Diane. And she showed a picture of herself as Diane, and her job offer was rescinded. So in this instance, you wanted her as a man, you don't want her as a woman. How is that not sex discrimination? And they also came up with this analogy of religious conversion. If somebody were fired because they converted from Catholicism to Judaism, would you then say that, well, that was just a change of religion? That's not actually religion-based discrimination. And that's exactly what was happening to trans people, just being carved out of these sex protections because of a change in sex. Another important case is in the equal protection context, but it was in the employment context. She was a state librarian in Georgia. And the court said, the 11th Circuit said, all persons, whether transgender or not, are protected from discrimination on the basis of gender stereotype. Brumby stated that it's unsettling, the employer, that it's unsettling to think of someone dressed in women's clothing with male sexual organs inside that clothing, and that a male in women's clothing is unnatural. So what happened was, it's like so classic. She came to work on Halloween in just, her costume was a woman. And, she was asked to go home and change. And, meanwhile, the person in the bunny costume was not unprofessional and was allowed to stay. But and this was strictly on a sex stereotyping theory. They didn't get into any kind of trans as protected class, but they did say that sex discrimination is subject to intermediate scrutiny under equal protection. But this is, in my opinion, what's really going on here. This is, there's a much simpler path to sex discrimination protections than advocates have kind of currently tried. And it's really, if you want to read more about it, there's a great note in the Harvard Law Review. And the note is about the Macy versus Department of Justice, which was the first time that the EEOC came out and said, sex protects trans people, regardless, because of that same logic that you can't discriminate against somebody for being trans without it being sex discrimination. And that was a federal employee, so when it's a federal employee, they can issue these opinions, and that's how the opinion got issued. But the note says the transgender discrimination is based on sex because it is rooted in aversion to or assumptions about biological sex characteristics. So there's a lot of advocates who want to make this about gender identity. And the title of this talk is Fighting for Gender Identity or something, Discrimination. And I didn't say anything, but so I could use it as an example. But so in our North Carolina case, that's exactly what North Carolina is arguing. They're saying, this is not sex discrimination. This is gender identity discrimination. You are expanding the definition of sex, and that's not right. And I don't want, we don't need to go down that path, particularly in the case of an exclusion for sex change, an exclusion for surgeries that change sex characteristics for the purpose of changing sex characteristics. If somebody needs a hysterectomy because they have endometriosis, or they need a mastectomy because they have cancer, those surgeries change sex characteristics, but not for the purpose of changing sex characteristics. You can have those same surgeries, and if the diagnosis is gender dysphoria, if you're deliberately changing them, that's why those surgeries are being targeted, because they change sex characteristics. And so North Carolina wants to argue that sex means biologically male and biologically female. And I say, sure, let's go with that, because how else do you define sex other than, actually, let me ask you, what are the medical factors that determine sex? What else? Hormones. No one wants to say genitals. Okay, I'll say it. Hormones, internal reproductive structures, whether you have testes or ovaries, whether you have prostate, uterus, and also your brain. So, gender identity is not something out in the ether. It is rooted in biology, and that is a factor that determines your sex, and arguably that is the factor that should determine your sex. So if they want to say that sex means biological sex, I say fine, and you're discriminating because someone wants to change their biological sex characteristics. So that is clearly within your definition of sex, and it's prohibited discrimination. So that's where I'm going to go. And I will just, before I open up to questions, I just want to mention, if you have a friend or you need healthcare, on our website at transcendlegal.org, there's videos that get into more specific details about how to know what your plan covers, how to apply for coverage, what to do if you're denied, that kind of thing.
Thank you so much.